Disclaimer. Wren Technology Services is registered in the BVI. We are a consultancy firm that provides technology services. This video, voiceover, is a true translation of the British Virgin Islands Commission of Inquiry report of the Commissioner, the Right Honourable Sir Gary Hickinbottom. Presented to His Excellency John James Rankin CMG, the Governor of the Virgin Islands, April 4, 2022. None of the text from the report was changed and was transcribed as reported by the Commissioner. The purpose of the translation is to make sure that the general public would have the full opportunity to hear the text as it is presented in the report. Wren Technology Services or its owner has no political affiliation or would ever collaborate with any political group to mislead the public. Please notify us if there is an issue with the transcription.
Elected public officials' interests. Continuation. Section 66 and 67 of the Constitution. 4.79 Section 66 of the Constitution provides for certain categories of person, e.g. anyone who holds any public office, is bankrupt or has been sentenced to a term of imprisonment of 12 months or more in the last 5 years, to be disqualified from being an elected member of the House of Assembly. 4.80 A particularly relevant category is that set out in Section 66, 1f. No person shall be qualified to be elected as a member of the House of Assembly who f. is a party to, or a partner in a firm or a director or manager of a company which is a party to any contract with the Government of the Virgin Islands for or on account of the public service, and has not, within 14 days before his or her nomination as a candidate for election, published in the Gazette or in a newspaper circulating in the Virgin Islands a notice setting out the nature of such contract and his or her interest, or the interest of such firm or company, in it. This provision does not disqualify someone who is in some way a party to a government contract from running for elected office, merely those who have not publicly declared such an association, in the required form, prior to election. 4.81 Section 67 provides that, in certain circumstances, other than at a dissolution, a member of the House of Assembly must vacate his or her seat in the House, including 3. An elected member of the House of Assembly shall vacate his or her seat in the House. Subject to subsection 7, if he or she becomes a party to any contract with the Government of the Virgin Islands for or on account of the public service, or if any firm in which he or she is a partner, or any company of which he or she is a director or manager, becomes a party to any such contract, or if he or she becomes a partner in a firm or a director or manager of a company, which is a party to any such contract. The section further provides, so far as relevant. 7. If in the circumstances it appears just to the House of Assembly to do so, the House may exempt any elected member from vacating his or her seat under subsection 3. If such member, before becoming a party to such contract as there described, or before or as soon as practicable after becoming otherwise interested in such contract, whether as a partner in a firm or director or manager of a company, discloses to the House the nature of such contract and his or her interest or the interest of any such firm or company in it. 8. Any request by an elected member for exemption under subsection 7 shall be made by way of motion, which shall be placed on the order paper for a decision of the House of Assembly. 9. In any case in which the House of Assembly, under subsection 7, decides not to exempt an elected member from vacating his or her seat, the member may appeal to the High Court against the decision, and subsections 4, 5, and 6 shall apply in the same manner as they do in the circumstances there specified. 4.82 Sections 66 and 67 are in materially the same terms as Sections 29 and 30 of the 1976 Constitution and have therefore been enshrined in the Constitution since at least June 1, 1977. They complement and strengthen those other provisions and safeguards that act as a check on conflicts of interests that are considered elsewhere in this chapter. 4.83 The requirements of Sections 66 and 67 are on their face draconian, but there is an inbuilt flexibility. So, as noted above, a candidate will only be disqualified from election to the House of Assembly under Section 66, 1f, if he or she fails to declare publicly an interest of the identified type prior to election. Similarly, though the general rule in section 67(3)(e) is that a member must vacate his or her seat upon becoming party to a government contract that is subject to the exemption in section 67(7). The rationale for this exemption is clear. It assists with stability of tenure and takes account of local circumstances. As the Attorney General submitted 142. Without an exception of this nature, there would be obvious practical difficulties, particularly in a jurisdiction such as the Virgin Islands, where because of the population size, there is a relatively small pool of potential candidates for elected office. Any such candidates who have significant business interests and experience, characteristics which may be attractive to the electorate, may be unwilling to seek or remain in elected office if to do so would exclude them from being able to compete for government business. 4.84 There are, however, issues of construction and interpretation in relation to both sections, the implications of which are potentially wide-ranging and of some constitutional significance. 4.85 Before turning to these issues, it may help to clear the decks of matters which are less controversial. In respect of these provisions, contract should be given its natural and ordinary meaning 143. Although certain members have in practice not treated purchase and/or works orders as contracts for these purposes 144, as a matter of legal construction, all forms of legally binding and enforceable agreement fall within the scope of sections 66 and 67, including petty contracts 145 and contracts based on work orders and/or purchase orders. 6. A party to a contract is an individual or corporate entity who has rights and/or obligations under the contract, who is legally entitled to enforce the contract and against whom the contract may be enforced. 7. The government of the Virgin Islands comprises the governor, the executive, including cabinet, ministries and government departments, the legislature, the judiciary. A contract falls within the scope of sections 66 and 67 if any government entity is a party to it provided, of course, that it was acting for and on behalf of the public service, as that term is defined in section 2(1) of the Constitution, 148. Sections 66 and 67 do not apply to a contract between two entities acting in a purely private capacity and not on behalf of the BVI government. 8. The purpose of section 66(1)(f) is to give the electorate full details of any contracts that the candidate has with the BVI government. This is achieved by publishing a notice in the Gazette or other appropriate newspaper setting out the nature of the contract and the candidate's interest in it. However, there is no prescribed form for the notice. There is some confusion as to what a notice should contain 149 and no consistency as to the disclosure made. 9. The procedure for obtaining an exemption under section 67(7) is time-consuming and cumbersome. It involves the member alerting the clerk of the House of Assembly, who instructs the Attorney General to draft the motion which the Premier then brings to the House. The process can take several months. 150. When it comes to the exercise of the discretion in section 67(7), there are no guidelines. Whilst the statutory preconditions must be satisfied, if they are, then whether an exemption application is allowed or disallowed is a matter for the House of Assembly, whose discretion is unfettered. Individual members may request further details about the contract and the motion is debated in the House of Assembly. Such motions are rare, and are usually passed. 151. 4.86 In the course of the submissions I heard, two issues arose in relation to the construction of sections 66 and 67. Issue 1, the exemption in section 67(7) of the Constitution. 4.87 The first issue concerns the circumstances in which the House of Assembly can properly exercise its power under section 67(7) to exempt a member from vacating his or her seat as otherwise required by section 67(3)(e). 4.88 These provisions have historically been applied in practice so that a member whose firm or company enters into a contract of the type described in subsection 3(e) is able to disclose the interest and seek an exemption as soon as practicable after the contract has been entered into. 4.89 However, there is a construction of these provisions into which this practice would not fall, namely that the House of Assembly's power to exempt only arises if one of two conditions is satisfied. I. The relevant member, before becoming a party to a contract of the type described in Section 67(3)(e), a government contract, discloses to the House of Assembly the nature of the contract and his or her interest, or the interest of any relevant firm or company, in it, the first limb, or, 2, the relevant member, before or as soon as practicable after becoming otherwise interested in a government contract, discloses to the House of Assembly the nature of the contract and his or her interest, or the interest of any relevant firm or company, in it, the second limb. The first limb covers all circumstances in which a member becomes a party to a government contract, be that as an individual, as a partner in a firm, or as a director or manager of a company. A condition precedent to the exercise of discretion in Section 67(7) is that these contracts, and the relevant interest, are disclosed before the contract becomes legally binding. The second limb, by contrast, covers any other circumstances in which a member becomes interested in a government contract, i.e., any circumstances other than those covered by the first limb. Those interests still need to be disclosed, as a condition precedent to the power to exempt arising, but they do not need to be disclosed prior to obtaining the interest provided they are disclosed as soon as practicable thereafter. 4.90, Sir Geoffrey Cox QC, for the Attorney General, initially acknowledged that this construction has at least a superficial appeal, or, if not appeal, force. He also accepted that there are two limbs to the Exemption 155, and that those members caught by the first limb must make the relevant disclosure prior to becoming a party to the contract if they are to benefit from the Exemption 156. However, upon reflection, he did not consider the construction to be correct. He submitted that the provisions draw a distinction between an individual member who enters into a contract with the BVI government, who falls within the first limb, and is required to disclose his proposed interest and obtain an exemption prior to entering into the contract, and a member who is a part of a company or firm which contracts with the BVI government, who falls within the second limb, and does not have to obtain an exemption prior to the contract, but only as soon as practicable. Afterwards, Sir Geoffrey's argument, in short, was that the key words in Section 67(7) are, before becoming a party, a director of a corporate entity or a partner in a firm does not become a party, the company/partnership does, and that, in these circumstances, the member is only otherwise interested in the contract. 4.91, I accept both that the interpretation favored by Sir Geoffrey has considerable force, and also that it is consistent with long-held practice. However, this interpretation introduces a distinction between a member who trades in his or her own name, and one who trades through a company or partnership. It is arguable that that distinction is artificial and arbitrary. Sir Geoffrey speculated that the rationale for this distinction may be to deal with those circumstances in which a director/partner/manager is not involved in day-to-day operations, and therefore may be unaware of the existence of the contract. However, for example, a company might be the member in corporate form, and a partnership might comprise the member and a sleeping partner. It is a somewhat strange use of language to import a subjective element of knowledge into the requirement to disclose an interest as soon as practicable, and to do so would potentially render Sections 66 and 67 toothless. It would be extremely difficult for the House of Assembly to consider whether a member did or should have had knowledge of a particular Contract 159, and, in practice, they do not seem to be subject to searching inquiries. 2. The words as they're described in Section 67(7) appear to link directly back to Section 67(3)(e), and the circumstances that are set out there. It is arguably significant, therefore, that Section 67(3)(e) does not distinguish between contracts entered into by a member in his or her own right, and contracts entered into by a firm or company of which the member is a partner or director. If the distinction is not made in Section 67(3)(e), then it raises the question as to the rationale for making it in Section 67(7). It is arguable that the more natural construction is that no distinction should be made, that both individual and corporate entities are covered by the first limb and that the second limb deals with something else entirely. 4.92. I do not need to resolve this issue of construction for the purposes of this inquiry. I seek only to emphasize that there are respectable alternative interpretations of Section 67, on one of which the long-standing practice, and, consequently, the continuance of certain individuals as members of the House of Assembly, would be unlawful. This would have significant constitutional implications. There is no evidence that any current members have become a party to a contract as individuals 160, but, if the current practice is not in accordance with Section 67 as properly construed, Hon Neville Smith, for example, would be caught by Section 67, 3e, as the director of a company that is party to government contracts for which no exemption was obtained prior to contract, and he would be unable to now avail himself of the exemption in Section 67, 7, 161. This is consequently a matter that would benefit from clarification. I shall make a recommendation accordingly. Issue 2, Statutory Bodies. 4.93, the second issue can be put quite shortly. Does the government of the Virgin Islands in Section 66, 1f, and 67, 3e, include statutory bodies? 4.94, it is quite clear from the evidence that the prevailing practice assumes that it does not, and therefore a member need not vacate his or her seat under Section 67, or seek an exemption, if they become party to, or otherwise interested in, a contract with a statutory body. This view appears to be based on advice given by the former Attorney General Hon Baba Aziz in March 2015, which indicated that statutory bodies were not within the scope of Section 67 because a statutory corporation is a distinct and separate juridical entity apart from the government of the Virgin Islands, as that latter term is used and understood under the Constitution and laws of the Virgin Islands. The Constitution distinguishes between a statutory body and the BVI government, and, if the former were intended to be caught by Section 67, it would have expressly said so. This construction, the advice says, is reinforced by a line of authority to the effect that statutory bodies generally enjoy a separate and independent status to that of the government, and by the language of the enabling legislation 165, which established the BVI Health Service Authority 166 as a distinct legal entity from the BVI government. 4.95, the analysis in the advice is powerful, particularly in circumstances where the relevant statutory body is truly independent and autonomous 167. However, the advice was given by the former Attorney General some time ago. It is unclear if the law may have developed in the intervening years, or whether it is a view that is shared by the current Attorney General. 2. The interpretation of the former Attorney General has not always been applied. A former Speaker vacated his seat for contracting with a statutory board, as confirmed by the Attorney General. I believe that, around late 1995/early 1996, the Hon Speaker at the time, Mr. Keith Flax, demitted office on account of a failure or refusal to seek a Legislative Council exemption for entering into a contract with the government. I understand that this matter involved a lease whereby Mr. Flax rented/leased his building or part of it to the Tourist Board, a statutory body, without seeking an exemption from the Legislative Council. The 1976 Constitution would have been in force at the time. 3. In any event, an Attorney General cannot make an authoritative pronouncement on the law. A request by the then Leader of the Opposition, Hon Andrew Fahey, to refer the matter to the Eastern Caribbean Court of Appeal 171, was rejected by Attorney General Hon Baba Aziz in 201-7172. The mere fact that this request was made indicates the position is far from settled, and the tone of the request suggests there are strong alternative views. This is reinforced by the current Attorney General's letter of October 15, 2021, which refers to the matter as a live issue amongst members. Again, although of some real importance, this is an issue which it is not necessary for me to determine under my terms of reference. However, it is again an issue that would benefit from clarification, particularly in the context of the evidence I have heard which casts serious doubt on the independence and autonomy of certain statutory boards. It is enough simply to point out that this has been a long-standing issue that is still not settled and that has potentially significant constitutional ramifications. Again, I shall make a recommendation accordingly. Declarations of interests in Cabinet. 4.97. Paragraphs 2.23 to 2.25 of the Cabinet Handbook 200-9176 concern the declaration of interests by ministers for the purposes of Cabinet discussions and decisions. They provide 2.23 Ministers and members of Cabinet attending meetings in relation to matters in which they have an interest must declare their interest or members of their family interest. Interests, whether private, pecuniary or non-pecuniary of ministers, members of Cabinet or their immediate family must be declared prior to discussions, if their participation is likely to give rise to a conflict. 2.24 Declaration of interest should be recorded by the Cabinet Secretary. Following the declaration of interest, it is then for Cabinet to excuse the minister or member, or for that minister or member to excuse himself, or for Cabinet to allow that minister or member to participate in the discussions thereafter. Ministers or members should excuse themselves from the discussions where a close relative is being appointed to a position in government or a statutory body. Once a declaration is made on a particular matter, it is not necessary for that minister or member to declare his interest in subsequent discussion on that particular matter. However, if the colleagues of the minister or member are not aware of the interest due to the passage of time, the minister or member is advised to reiterate his previously declared interest. 2.25 Ministers or members having doubts or uncertainty about their interest in a Cabinet matter should inform the Premier in advance of the matter coming up for Cabinet discussion. 4.98 As with the declarations of interests under the Register of Interests Act, there is no guidance as to the application of these provisions, and there was again a wide divergence in views as to the circumstances in which a member of Cabinet should recuse himself or herself. 4.99 The Premier said that there had been discussion in Cabinet as to the extent of the conflict of interest provision as applied to family members when the Cabinet Handbook had been prepared. He did not recall ever recusing himself from any Cabinet discussion/decision. He accepted that, even if the Cabinet Handbook did not require it, those who live in the BVI might perceive a conflict of interest where a particular minister were to be involved and voted upon the appointment of his or her uncle or aunt to a position on a statutory board. 4.100 It is clear from the evidence that there is currently no consistent approach to declaring interests prior to Cabinet discussions, a proposition accepted by the Premier 181. Given the confusion and ambiguity as to what interests/relationships should be declared, it is remarkable that no proper guidance has been issued, and, according to the evidence, no Cabinet member has ever sought clarity or guidance from the Premier as provided for in paragraph 2.25 of the Cabinet Handbook. 4.101 At a practical level, there are no mechanisms in place to check whether the appropriate declarations have been made. It is essentially a trust-based system. That was the evidence of the Cabinet Secretary Sandra Ward, who said that the responsibility for declaring a conflict falls to the individual Cabinet member, and she was unable to speak to how potential conflicts are identified. 183. The general attitude appears to that most interests will happen to be known and somehow picked up by other Cabinet members due to the small size and closeness of the population. Hon Carvin Malone, for example, was confident that he would be reminded by the Premier or the Attorney General were he to forget to declare an interest. 184. The Cabinet Secretary accepted that the system could be strengthened by requiring Cabinet members to provide a list of their interests to the Cabinet Secretary prior to a Cabinet meeting. 4.102 In terms of governance, recusals from Cabinet are not reported, so the public do not see the system, such as it is, working.